Good morning, everyone. Welcome back to the Nevada State Legislature, back in full session. Glad to see everybody made it through the weather, everyone's safe and sound. Again, this is our first time back in committee since Thursday, so glad to see you all back. Just want to welcome you to Assembly Judiciary and welcome those, not just here in Carson City, but online watching through Nellis or the YouTube, our legislative YouTube channel, as well as those in Las Vegas. And with that, Secretary, please take roll.
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick.
Here.
Chair Miller.
Here. And looks like everyone's present. So with that, we will, just a few housekeeping issues. Just want to remind everyone to turn off all of the volumes and rings and anything that would make noise on any of your electronic devices. While you see us up here, we are using laptops and electronics, but that is to stay engaged, and we're doing research and communicating and asking questions. Please don't take that as a sign of not paying attention or being inattentive. We will have a public comment section at the end of today's meeting. And with that, we will go ahead and get started. Today, we are going to take the agenda out of order. We will hear Assembly Bill 193 and then Assembly Bill 101. So with that, and those will be our two bills for today. With that, I would like to open up the hearing for Assembly Bill 193 and welcome our bill sponsor, Assemblywoman Gonzalez, up to the table. Assembly Bill 193 revises provisions relating to custodial interrogations of children. And so we'll give you a few moments to get settled. Assemblywoman, when you're ready, please proceed.
Good morning. Thank you so much. It feels so great to be back in Judiciary. Not only to be back, but to have a whole day dedicated to you. So really excited to be with you all this morning. Thank you, Madam Chair and members of the committee. For the record, my name is Assemblywoman Cecilia Gonzalez, and I represent Assembly District 16 in Clark County. And I'm here today to present Assembly Bill 193. To help me present is Nathaniel, the State Policy Director at the Innocence Project. Police officers have a legal and ethical responsibility to uphold the law and protect the rights of all individuals, including children who are in custody. Lying to a child in custody can violate these responsibilities and potentially harm the child's well-being. Children who are in custody are often vulnerable and may already be experiencing high levels of stress and anxiety. And lying to them can absolutely exacerbate these feelings and also may lead to false confessions. Assembly Bill 193 prohibits a peace officer or other person authorized to conduct a custodial interrogation of a child from providing false information about evidence and making promises of leniency or advantages to a child during an custodial interrogation. I've invited local law enforcement and district attorneys to several roundtables to discuss how to make this bill work in Nevada. I know that there's still some general concerns, and I've asked them to bring specific language and ideas raised by these concerns, and we're still in the process of working that out, which I'm sure you'll hear in their testimony today. I believe firmly that no one should be lied to by law enforcement, but this is a narrow and tailored bill that will address an important issue of protecting children. While a person may be charged for lying to law enforcement, this bill carries no penalties for law enforcement who violate it and solely focuses on protection from children from false confessing. Utah, most recently, and several other states did not wait for an innocent child to spend 20 or more years before enacting this policy in their state. Let's not wait for a child here to be harmed in our state to enact this law. And with that, and your chair's permission, I will turn it over to Nathaniel.
Good morning. I apologize for bringing the snow. This is the second state I've visited in the last couple of weeks that's had a snowstorm that I've landed in. But for the record, my name is Nathaniel Erb. I am a state policy advocate with the Innocence Project in New York, here on behalf of myself and representing also local innocence organizations in Nevada. We have been working on issues of false confessions for many years. as we represent people who've been wrongfully convicted across the country, our office works on studying what are the causes of those wrongful convictions in the first place. And in this area, we've actually found a lot of partnership and collaboration with law enforcement themselves. You'll hear from some experts this morning speaking to this, but the International Association of Chiefs of Police called for law enforcement to cease using deceptive tactics, including lying about evidence, falsely promising leniency to children in interrogations, because they found it not being an effective interrogation tool, but also causing false confessions and leading to unreliable information. Since the passage of those guidance, 5 states have enacted laws in the last couple of years to ban the use of these tactics, to focus solely on how do we protect children when they falsely confess, how do we ensure that there are proper mechanisms in the courtroom to judge whether or not a confession is reliable. The current issue with the standard under the Constitution is that voluntariness does not capture if a confession is reliable. That is in the ruling of the Supreme Court. The Supreme Court has not said that deception itself is a constitutionally important tactic to law enforcement that needs to be used in all contents, but simply that the due process clause did not protect against those tactics being used in interrogations. And as further, the Supreme Court has said on many occasions that deception seems to fly in the face with a system that focuses on guilty before proven innocence and is not an inquisitorial system. This bill specifically is very narrowly tailored to focus on juveniles. It requires that the officer has a knowing intent to provide false information, so it's not going to capture someone if they believe the information to be true but turns out later to be false. And it also requires that the court provide an analysis that the false confession itself or the information provided itself has a nexus to likelihood to elicit a false confession. I think this is a very good bill that unanimously passed in Utah, that with the full support of law enforcement and prosecutors, but that doesn't mean it's a bill that Nevada has to pass. There could be changes to this language to make it fit the context here. We've had a lot of really good conversations on this bill, as we had in many times in the past with law enforcement and prosecutors, so I thank them for their time working on it. I'm confident we're going to get to a place where we can move something forward that's going to protect children and will show that law enforcement here do not think that our justice system needs to result and be based on lies. So with that, I think we'll turn it over to our guest speakers. So first, I believe Marty Tankliff is here on the Zoom to speak to you.
Cecilia Gonzalez, for the
Yeah,
record. I just wanted to clarify that we had a couple experts on the Zoom. So just if folks are wondering who they were, they will introduce themselves and explain their areas of expertise as well. Thank you.
Good afternoon. My name is Marty Tankliff. I am the Peter P. Mullen Distinguished Visiting Professor at Georgetown University. I'm also an adjunct professor of law at Georgetown University. I'm also special counsel to Marquette, Epstein, Karen Aldea, and La Turca in Gardens of New York. Finally, I'm an exoneree from New York State. And if the state of New York would have had their way, my first eligible parole would have been October of 2040. That's because on September 7th, when my father was attacked in our home and I murdered his mother, instead of law enforcement focusing on who committed these crimes, they chose to bring me into an interrogation room and lie to me. Those lies rose to the level of what I would say were atrocities. I was told that my father had identified me as being the murderer. They told me that my hair was in my mother's hands. They told me that a humidity test was done that morning. All this was done because in New York State, it was legally allowed. Additionally, what happened in the interrogation room was not recorded. Suffolk County law enforcement chose not to record any aspect of the interrogation, even though they had the policies and procedures and the technology in place. No child anywhere in this world should be lied to by law enforcement during an interview or an interrogation. We know through empirical evidence that when you lie to a child, like me, it can lead to a false confession. On September 7th, after hours of interrogation, law enforcement said I confessed to them. Within a few months, I was sentenced to 50 years to life. I want everyone to imagine what 50 years to life being a child is like because law enforcement lied to you. We need to do better. We need to change the law, and I'm really hoping this legislative body takes the necessary steps to protect innocent children from this ever happening to them. There should be no more Marty Tankliffs. We should step forward, enact the law now, and not wait any further, because we need to protect our children. There have been too many youthful suspects that have been lied to during interrogation, such as myself, that have spent decades in prison. Thank you.
Thank you so much. Next, we have Dave Thompson.
Great, thank you. Thank you, Madam Chair, members of the committee. For the record, my name is Dave Thompson. I'm a certified forensic interviewer. I'm also the president of a firm named Wicklander Zalowski and Associates. We're an international training firm that for over about 4 decades now have provided consultation and training on interview and interrogation techniques to federal, state, local law enforcement. I also often serve as an expert witness on confession reliability. And on this specific legislation, I've had the opportunity to be a part of similar efforts across the country in multiple states with mostly bipartisan support, working collaboratively with law enforcement leadership across the country to understand how this proposed bill impacts their ability to resolve cases. And with that all being said, I'm here in support of Assembly Bill 193. The 2 main points I want to make with my testimony today is first, why we shouldn't use this tactic, and then secondly, why we don't need to. Primarily, why we shouldn't use this tactic, you've just heard from my colleague, Mr. Tankliff, on the impact of false confessions. You'll hear shortly from Dr. Cleary on the social science on how this contributes to false confessions. But from a strategic standpoint, from a law enforcement perspective, one of the reasons that we shouldn't use this tactic is honestly the same reason investigators do use this tactic, is it works. Is we know that when investigators fabricate evidence, it creates memory distrust in the person that they're talking to. It creates potential confusion, right? How can you have my DNA if I wasn't there? This confusion and distrust is often then misclassified as guilt. And when something's misclassified as guilt, it then is a catalyst to a coercive interrogation process. Now, we're not typically talking about ill-intended officers, right? We're talking about investigators that are trying to get to the truth, trying to resolve a case. But we have to also understand that the only reason we lie about evidence in the first place is because we don't have it. And if we don't have it, that means we're using this false evidence ploy as a presumption of guilt, as a tactic to determine if somebody was involved or not. And it's been proven time and time again that that tactic is not a good indicator of truth versus guilt, or innocence versus guilt, truth versus deception. Another really main contributor from a strategic standpoint of why we shouldn't use this tactic, it damages the credibility of the investigator. I'm sure we'll hear from law enforcement on some of the difficult cases they have to investigate, especially some violent crimes. And we have seen that when you have to talk to a person who happens to be an offender multiple times, somebody that they have to talk to throughout maybe their lifespan, if you lie to somebody when they're 16, 17, 18 years old, and then you hope to make them an informant or a cooperative witness at some point later down in another investigation, you've lost that advantage. And police community trust is paramount in this entire process, and lying to our community only disrupts that plan. The second part of my testimony is really, I think, the main perspective that I can bring is why we don't need to use this tactic. We know law enforcement has a very difficult job in trying to get information from people who don't want to resolve it. And that's why I'm here. There's solutions to that concern. This tactic, we have to remember, dates back to a Supreme Court case from 1969. The availability of evidence has changed drastically over the last 6 to 7 decades of how we can actually investigate versus resorting to lying about evidence. In the last several years, there's been collaboration between academics and practitioners to find more effective ways to get information from witnesses, victims, and suspects through reliable evidence-based means. You're going to hear from my colleagues today on some different ways to do that. From our perspective, we have seen multiple evidence-based methods used by law enforcement agencies across the country with success. Things like the cognitive interview, the peace model, the strategic use of evidence, trauma-informed interviewing, all widely used evidence-based acceptable practices that we're seeing are gaining more information than these coercive tactics. So to conclude, I understand, obviously, on behalf of law enforcement trainers, that law enforcement has a very difficult job in trying to get information from people who don't want to provide it. But I firmly believe that this legislation not only will improve the quality and effectiveness of investigative interviews, but it also will restore and rebuild trust between law enforcement and the community. Thank you. I appreciate your time today.
Thank you so much. Next, we have Dr. Haley Cleary.
Hi, good morning. Thank you for inviting me. My name is Haley Cleary. I am an associate professor of criminal justice and public policy at Virginia Commonwealth University in Richmond, Virginia. And I'm a developmental psychologist by training. So my area of expertise is in adolescent behavior and decision making in legal contexts, and primarily interviewing and interrogation and confessions among young people. And so what I'd like to take just a few minutes to do today is to share with you a few of the things that we've learned about adolescent development and how their developmental stage impacts their thinking and behavior when they're being questioned by police, and why youth in particular are especially vulnerable to deception and to promises of leniency. So the first point I'd like to highlight for you is that youth's incomplete brain development hinders their decision making under stress, right? So we know as developmental psychologists that the human brain isn't fully functional until actually the mid-20s. And it's interesting and important that the brain develops along different timetables. So the limbic regions of the brain, which are the parts that control emotion and reward sensitivity, those parts of the brain develop faster than the cortical regions of the brain that help us with executive functioning and self-control and emotional regulation and judgment, thinking about the future, that kind of thing. And so what this all kind of rolls up into is that youth are literally less able to think about the future because of their developmental stage compared to adults. And so if you kind of combine this with youth's incomplete knowledge about the legal system, we know that youth are more likely than adults to misunderstand the legal implications of confessing to a crime, a true confession or a false confession, especially without the assistance of counsel, which we know that so many youth are questioned without a support person present. The next piece of research that I like to share with you is that youth are more suggestible than adults. So suggestibility means the degree to which we come to accept messages that are communicated to us, either directly or by implication, including information about a false evidence, right? And so police are trained to use these techniques, to use leading questions, to offer excuses or justifications to make the crime seem less serious. And research shows that adolescents are more suggestible and more prone to actually change their answers in response to that kind of negative feedback. And this is especially the case for youth with intellectual limitations, which we know kids from that population are overrepresented in legal system contexts, so they're especially vulnerable. Now, suggestibility is a little bit different from compliance. Compliance involves agreeing to propositions that are not your preference or not your idea, just to avoid someone or to avoid confrontation, excuse me. And, you know, if you think about from a social perspective, youth are socialized to obey adults every day in their lives, whether it's, you know, listening to your parents, following the teacher's rules, you know, adult leaders in the community. So when an adult police officer, particularly a police officer who's uniformed and maybe armed, or even multiple officers, when those people use deception to obtain cooperation or confession, youth are less able and less likely to advocate for themselves and more likely to acquiesce to police pressure. And I mean, that is highlighted so tragically well with the testimony that Mr. Tankleff provided. And I think his experience really highlights some of these critical pieces of adolescent development that we've learned a lot about over the last 3 decades. The last 2 pieces that I'll mention very quickly are that youth know less about the legal system than adults. So we've known for a long time that youth, by and large, do not understand the Miranda rights. They waive their rights at extremely high rates without understanding the words and concepts inherent in those rights. And this is also a function and feature of that compliance and suggestibility related tendencies that I was mentioning a bit earlier. What we've learned very recently through a couple of very recent studies is that youth in particular, and even some adults, don't know that police are legally permitted to lie. And so when police are allowed to use deception and youth don't know that they're allowed. Youth come into that interaction expecting everything that is told to them is true, and they make decisions, difficult and legally consequential decisions within that framework and within the limited biological and neurobiological capacities that they have, because they're works in progress, right? Their brains are not, they're not fully baked yet. The last piece that I'll point out about adolescent brain development in particular that's relevant to deception and promises of leniency is that adolescent brains are hardwired to respond to rewards. It is a neurobiological preference that is a function of the stage of development in which young people are in. And this broadly covers all of the teenage years, even through the emerging adulthood years, so people beyond the age of 18. So the idea of escaping a situation that is stressful, that is confusing, that is frightening, exerts a stronger neurobiological pull on young people than adults. And so that makes particular forms of deception, like implying leniency, especially dangerous. A young person who hears or an interrogator say, or even imply that, this will all be over, essentially, if you cooperate or you confess, young people are going to be much more sensitive to those short-term rewards, the reward of relief, than a person who is fully reached the age of neurobiological maturity. So these are some of the things that we've learned about why and how youth are especially vulnerable to deception in this particularly stressful context. I think it's really, really outstanding from a social science perspective that the Nevada Legislature is considering this bill. It's very much an evidence-based bill that is in line with the most contemporary social science research and neurodevelopmental research as well. And we've seen this in a handful of legislatures across the country. And I think you have an opportunity to really be a thought leader in this space. And as a scientist, I always strongly promote and endorse evidence-based bills, and AB 193 definitely falls into that category. Thank you.
Thank you so much. We have two more presenters. Thank you so much. Jen C. Anderson and then Mark Fallon. Thank you.
Good morning, and thank you so much for having me, Madam Chair and members of the committee. My name is Jen C. Anderson. I am a professor of law at the S.J. Quinney College of Law at the University of Utah. I'm also a founder and former legal director of Rocky Mountain Innocence Center, which is the regional member of the Innocence Network, whose mission is to prevent wrongful convictions in Utah, Wyoming, and Nevada. I am here in enthusiastic support of AB 193. We were able to pass a similar bill in my home state of Utah last year, and I'm thrilled that the Nevada Legislature is considering this bill. One of the most counterintuitive aspects of human behavior is the decision to confess, and in particular, to do so falsely. While many understandably believe that a false conviction is atypical, we've discovered that through DNA-based exonerations, that it's a frequent contributing factor to wrongful convictions. In fact, it's the most common contributing factor among homicide exonerations, and it's present in 30% of all exonerations proven through DNA. One leading study of 125 proven false confession cases found that 63% of the false confessors were under the age of 25, and 32% were under the age of 18. Another respected study of 340 exonerations found that juveniles under the age of 18 were 3 times more likely to falsely confess as adults. Leading law enforcement organizations, such as the International Association of Chiefs of Police, also agree that children are particularly likely to give false confessions during the pressure cooker of police interrogation. In Nevada alone, Robert Hayes, Kathy Woods, Kristen Lobato, and Fred Steese were collectively wrongfully convicted and imprisoned for over 85 years, in part due to false confessions. And the criminal justice system, as Nathaniel Erb pointed out, just does not work to identify what the protections in place now just don't work to identify an innocent person who may have falsely confessed. Courts weigh the veracity of confession, and whether it's coerced or not, they look at the totality of circumstances, which is why we have 400 examples of false confessions having been admitted in court. Judges and juries tend to believe confessions even when there's conflicting DNA evidence, since historically it's impossible to discern a true confession from a false one. And as Nathaniel pointed out, the Supreme Court has established that there's no constitutional reliability requirement for the admissibility of confessions. In the past, most courts consider confessions voluntarily and therefore admissible, as long as the police provided Miranda warnings and the defendant knowingly waived them. The existing framework just does not identify coerced or unreliable confessions, and as a result, exonerations involving false confessions repeatedly occur. Thus, coming to you from the innocence perspective, we again enthusiastically support AB 193, believe that it's good policy, and would encourage you to listen to all of these amazing experts who have testified and pass this bill. Thank you very much.
We could close. Thank you so much, Madam Chair, for allowing us to present. Oh, there's Mark. I think his is pretty short as well.
Madam Chair, members of the committee, thank you for the opportunity to testify today. My name is Mark Fallon. I'm a visiting scholar at John Jay College of Criminal Justice and co-founder and director of Project Aletheia, a center to bridge the gap between the science and practice of interrogation. I'm testifying in support of a bill to ban deception and deceitful police tactics during interrogation. Following the attacks of September 11th, I was a Naval Criminal Investigative Service Special Agent and led the Pentagon Task Force established to investigate terrorists for trials before military commissions. I have seen firsthand the consequence of inept practice and the desecration of the dignity of victims on both sides of the interrogation process. I have served as the director of the NCIS Training Academy and the assistant director for training of the Federal Law Enforcement Training Center. I spent 4 years on a 15-person global steering committee in furtherance of a United Nations initiative to develop a universal interviewing standard with an advisory council of over 80 experts from 40 countries. The Mendez Principles on Effective Interviewing was published in May 2021, and this summer it was endorsed by the American Bar Association. The principles call for interrogation practice and training to be based on law, science, and ethics. And I emphasize science for a reason. I have been involved in interrogation research since 2010, when I was appointed to the U.S. government's High Value Detainee Interrogation Group Research Committee, serving as its first chair. When the HIG was established, the U.S. government embarked on the most robust research program in the United States in interrogation in more than 50 years. More than 100 evidence-based and peer-reviewed studies were conducted. They support the efficacy of rapport-based approaches to obtain accurate and reliable information. This has been the catalyst for major reforms in interrogational practice. We know from this research that information gathering methods are superior to confession-driven methods, which are proven to produce false confessions, wrongful convictions, and miscarriages of justice. Juveniles are especially vulnerable and are impacted by deceptive practice and by untrained, poorly trained, or improperly trained officers. Officers need training, not trickery and deceit. The Mendez Principles provide guideposts for interrogation practice that are effective and just. The Federal Law Enforcement Training Centers have revamped their training programs and no longer teach coercive methods. They now instruct in only science-based methods, such as the strategic use of evidence and the cognitive interview, rather than legacy practices that relied on deceit and coercion. Elite investigative agencies such as the NCIS have rejected coercive legacy methods and now only train in and utilize science-based interrogation methods. Yet there are still too many confession-driven practices that exploit weaknesses and employ tactics that lack dignity. Especially at the state and local level, those have yet to embrace the science-based interviewing methods. Deceptive practice during custodial interrogation should be banned. The IACP has a model policy that can be used to establish policies, and the Mendez principles should be used as guidelines for the development of necessary training programs. Trust must be restored between the police and the public we serve. Policing with virtue can foster public trust, uphold the rule of law, professionalize the practice of policing, and move us a step closer towards community-embraced policing. Thank you for the opportunity to speak with you today, and I urge you to support this bill.
Thank you so much, Madam Chair, Madam Vice Chair, and members of the committee. I appreciate your patience with our different experts speaking on the issue. I just wanted to put on the record that this is not a call out or an attack on police. The intent of this bill is to protect our children. And with that, we'll take any questions. Thank you.
Thank you for your presentation, Assemblywoman. There are a few members that have questions. We will begin with Assemblywoman Bilbray Axelrod.
Thank you, Chair. So I wanted to confirm that the bill that we passed last session was signed where the kids' Miranda rights. And so I hope that that's being used. My question was actually, in Nevada, parents don't have to be present for an interrogation. And I was just wondering, do you know what age that starts at? Could a child as young as 8 or 9 be called in without a parent and have police interrogate them?
Would you like us to ask legal? Yes. And even though he is not present, he is listening. So I will just make sure, and we'll come back to that. Give him a moment to respond, okay?
Okay, great. Cecilia Gonzalez, District 16 for the record. I do want to note that in my conversations with police, like I've mentioned, we've had this very large working group, and unfortunately we couldn't find a comfortability before this hearing, so you will hear them testify. But they do mention that the Miranda rights are being stated, and in those working groups, a couple of officers have given different examples in where the Miranda rights are given. I think from our standpoint, a parent can waive a juvenile's constitutional right, and not really understand what that means. And so even though we have juvenile Miranda rights, I think this is further protections in place for juveniles when they're being interrogated. Thank you. Nathaniel, did you have anything else you wanted to add?
I just want to note that the National
your name for the record.
Sorry, for the record, Nathaniel Erb on behalf of the Innocence Project. We strongly support having counsel in interrogation rooms. There has been concern amongst defense attorneys nationally that the inclusion of parents alone without the presence of an attorney can actually negatively impact the rights of the child, because parents can waive the right of the child not knowing. Studies that have been produced around it have also noted that parents themselves are not aware that deception can be used, that the officer could be lying to the child in the circumstance. So while it's a good protection, it doesn't wholesale protect against this situation. And I believe, in all likelihood, law enforcement is not routinely lying to a child. But if someone breaks protocol, doesn't include it, a parent's not included, there's no protection on the back end for that child's confession in the courtroom.
Next question from Assemblyman Gray.
Hi, good morning. I commend you, Assemblywoman Gonzalez, on bringing this forward. I mean, I really appreciate you trying to protect our youth. I do think, though, that deception does play a role in interrogations. I would like to see the threshold on this and see if you're amenable to maybe dropping it down to 14 and, maybe adding something there that they won't be questioned without, an attorney present or something. I think there's just too many instances where they can use deception to trip up somebody's story or testimony, or if it involves more than one person, maybe getting somebody to roll on another person. I hate to use that term, but sometimes that's what you've got to do to be able to get to the facts and then align the evidence and the forensic evidence with the truth. So I just, like I said, I do commend you. I do know there's false confessions out there, but I would rather see rules put on that than just throwing the baby out with the bathwater, because I think it's a slippery slope. If you get into a court and say a law enforcement officer, said, quoted the student or the child as saying, well, you said you were here at this time, and this time, knowing that was false, to see if the kid would change a story or stick with it, well, now the whole thing is thrown out because the officer used deception as opposed to an outright lie saying, well, we know you did it and blah, blah, blah. I think it's just too much at once. So would you be amenable to some kind of amendments along those lines?
Cecilia Gonzalez, for the record, District 16. Thank you so much for your question. We are open to solutions and conversations, and we welcome them, especially with our large group. And so, I will definitely keep you updated and in the loop as this progresses. Thank you.
Thank you, Assemblyman. Our next question is from Assemblywoman Hardy.
Thank you, Chair. Good morning. Glad to see you. We all made it today. So my question, I don't know if this may be a question later for law enforcement or others. You may not be able to answer this, but several times it was mentioned that over the decades there have been different methods developed, science-based methods and like cognitive interviews, different ways of obtaining evidence and things like that. So my question is, what here in Nevada do we use those methods when we are questioning children? If you could address that, or maybe later. Thank you.
Cecilia Gonzalez, District 16, for the record. Thank you so much for your question. I think that's definitely a question for law enforcement to definitely ask them what are the current tactics that they're using. Thank you.
Thank you for the question. Our next question is from Assemblyman Ornlicker.
Thank you, Chair, and thank you, Assemblywoman, for the presentation and all the expert support, which was very helpful. And one of the comments about how children think, and they're very responsive to some promise of benefit. So that makes me wonder about 1B, where about express or implied promise of leniency. And the way it's worded is it can't be made by somebody who doesn't have authority to make that kind of promise. But presumably, would that mean if a prosecutor came into the room, could make that promise of leniency? And what kind of risk do we get of eliciting a false confession when the prosecutor comes in and makes that promise of leniency?
Cecilia Gonzalez, District 16, for the record. Thank you so much for the question. I'm going to let Nathaniel answer this one.
I think it's certainly, for the record, Nathaniel Erb on behalf of the Innocence Project, I think it's certainly an area of concern that we have. The origin of that comes from the first state to pass this was the state of Illinois, and the law was developed in partnership with the Cook County DA's office. They were trying to craft, with this section with us, a way to narrowly address the situation where an officer will often be authorized or in conversation with the prosecutor to provide some promise of leniency or say that we're going to work towards that. And they wanted to say, let's start out just getting at the situation as if the officer themselves are providing or implying leniency could be provided, and they have not had a conversation with the DA has not offered anything whatsoever or said they're going to work on anything, and the officer is then knowingly lying or knowing that they have not had that conversation, we're getting at those situations first. So I think it could be an area that we look at how to fine tune it so we're capturing more situations could be of concern, but the intention was to start with that narrow situation where there has not been a conversation between the DA and the law enforcement officer or the interrogator providing to say that we're going to work towards or we directly are going to provide some promise of leniency.
Thank you, Assemblyman. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair, and good morning. It's good to see you. You mentioned, I heard Illinois, Utah mentioned. Could you tell us some other states that have this in statute or maybe something similar? And then just off of that, the Utah law is not this exact, and just wondering how it's different. if you could answer that, or maybe Ms. Anderson. But first, what other states? Thank you.
Thank you, Assemblywoman Nathaniel Erb, for the record on behalf of the Innocence Project. 5 states as of today have enacted legislation, be Illinois, Oregon, Utah, Delaware, and California. Utah is the most stringent. It's in terms of both what would be captured. So it's drafted very similarly. There's a little bit of wording change, but kind of narrowly, these 2 cases were very specific about what that it's false facts, that those false facts are likely to elicit a false confession. That was a narrowing that was in conversation with law enforcement. And because of that is because it's governed in statute by the rule of evidence, saying the state has to demonstrate that the statute was adhered to. So if the state can't demonstrate that the officer did not violate this act, then it's strictly not allowed in courtrooms. All other states have allowed a little bit more leniency, starting with Illinois and Oregon, and then also Delaware, where rather than a strict bar, all those laws have a little bit more broadness of their terminology of what's captured, but they're saying there's a rebuttable presumption that the statement is inadmissible, and that the state would then just have to present evidence to show that the statement is still reliable and voluntary. So that would be, no state has limited what those factors of reliability should be, but things that have been pointed to are, is the statement in direct contradiction with other evidence? Did the statement lead to the discovery of new evidence that went to the person's guilt? Did the contents of the statement originate entirely with the interrogating officer, meaning all the facts that made up the entirety of the statement are actually facts that the officer themselves told the child, and none of them originated from the child telling the officer that information. So all those types of information could be weighed by a court in determining, yes, I realize the statute was still violated, but this proves that this is still reliable despite of that. And I think that goes to why other states have all pegged this at 18, and the move is now move above that. Vermont has just moved a bill that's at 21, and it also mandates a standard policy across the state requiring deception not being taught for anyone, including adults.
Thank you, Assemblywoman. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you all for the presentation. Mr. Irv, you and I had spoken previously about the custodial interrogation requirement in subsection 1, and I was thinking, can you tell us a little bit more about, for custodial interrogation, is that different for minors? I was thinking, for instance, does a child have an ability to get up and leave if they're, let's say, the police come to the school and ask for a child to be brought in, to the principal's office, and they start to ask them questions? Is that a custodial interrogation? Like, are there any kind of guidelines or differences between when a child's being interviewed, questioned, versus an adult? And yeah, if you could just go into some of those situations.
Yeah, so as it's defined by the bill, and just, Handler Erb here on behalf of the Innocence Project. The custodial interrogation, well, first of all, it was pegged to custodial interrogation largely because that's in which Nevada, as well as many other states, require recording of interrogations. So if we're going to be able to challenge the veracity of a statement, we should make sure it's recorded so that the evidence, it could be investigated, and it's not a swearing contest between who said what and when. Custodial interrogation as a defined term is a pretty well-defined term both in Nevada and across the country, as in general terms, when a person views himself to be under arrest, unable to leave, and it's kind of a mindset, but well established in the state. There is some consideration that a juvenile might view more situations in which they cannot leave from the presence of the adult or interrogator versus what an adult may view that. That would be up to the courts, and I think it's a well-established principle at this point. If that kind of helps answer. It's a little bit glossy, but I think it answers the question.
Could you take that offline so that we can continue? We still have a number of questions coming. Okay, thank you for that. Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you for the presentation and all of the experts on this particular bill. I was wondering if you know, and perhaps this is better handled by police or PDs or DAs, but I figured you have so much background on this topic, perhaps you would know if there is any special training that's given to the interrogators, to the DAs, or to PDs about dealing with children and their unique developmental stages and how to best serve children in this context.
For the record, Nathaniel Erb on behalf of the Innocence Project. Got it that time. I can't speak to specifically here in Nevada. I would defer to our law enforcement partners on what exactly their individual agencies are trained in. I will say that the International Association of Chiefs of Police report we referenced that first called for abandoning of deceptive and coercive tactics in this manner back in 2012 was developed because the IACP found that training largely across the country was uniform for both adults and children. There needed to be a separate subset of training directly focused on how do you work with a child, taking into account the prevalence of false confessions, taking into account the science we know about brain development. And through the development of the initial steps of those training that's been followed up on, one of the first things that they directly called against is do not use deceptive tactics. Do not falsely imply leniency, because that's going to lead you down a bad road. But I can't speak directly to what exactly law enforcement here in Nevada is trained on.
Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for bringing this critical issue to our attention. As someone who teaches 14 and 15 and 16-year-olds, I know exactly what you're talking about with the youth brain, and I can tell you they are children all the way up to 18 and even beyond, as your researchers shared. And my general policy is we shouldn't lie to children. It doesn't usually end well in my practice with students. And so I just wanted to speak a little to Assemblyman Gray's concerns about an officer lying to a child and not realizing they're lying, and then the case falls apart. Under this bill, if an officer is telling them information that they believe at that moment to be correct, that is still protected. Is that correct?
For the record, Nathaniel Erb on behalf of the Innocence Project. Thank you, Assemblywoman, for that question. That is still protected. I think it is still a concern that if an officer unintentionally provides false information, that can still have the same dramatic effect on a child in causing them to falsely confess to the crime, because the effect of the information is still true. But for the sake of crafting a bill that everyone can feel comfortable with and that no one's going to feel left out in the cold for making an unintended mistake, all the states have chosen to parse this along the lines of knowingly, so that there was a knowing intent by the officer to violate the act, to knowingly provide that false information. So they would have had the knowledge about what is true and what isn't true. And the defense attorney would have to prove that they had a knowledge and an intent to violate that.
Thank you, Assemblywoman. And our last question is from Assemblyman Urick.
Thank you, Chair, and thank you again for your presentation. I appreciate you also reaching out the other day and having communications with all the stakeholders to try to address this issue and maybe head off any potential problems. And I think something to clear up with what the Assemblywoman just said, I think, and you even said in your response, it looks like the language in there says knowingly. I think it would be good to add knowingly with the intent to provide. That would clear up some potential concerns that even that could result as a consequence of not having that there. My question actually is more along the lines of, I understand that confessions as a general rule are not the sole basis for a conviction. And while I applaud the effort to try to avoid false confessions, I do know that as it stands now, confessions are viewed under the totality of the circumstances by the triers of fact to try to determine its reliability already. And so I guess as I look at this issue as a legislator, I'm always trying to figure out any proposed policy. Are we trying to head off or address a real problem? Prior experience, 20 years as a law enforcement officer, I was unaware that there was a significant problem with this. And so while if it is a big problem, I'm wondering, is this a solution that's in search of a problem? Do we have specific data, either nationally or even more importantly here in Nevada, that indicates that we are, as a result of these interrogation and interview tactics that are currently being used by law enforcement, are leading to a high number of false confessions?
Cecilia Gonzalez, District 16 for the record. Thank you so much for your question. In specific examples of this, while people are under the age of 18. I think that maybe the public defender's office and the police can speak more to that. In terms of Nevada in general, I think in the next bill you will hear how, we have been the center of a national attention for false confessions and what that has led to for people being incarcerated. I think Nathaniel has more that he can speak to on that.
Thank you, Assemblyman. Nathaniel Erb, for the record, on behalf of the Innocence Project. First, thank you for your good point. I think that's a simple, easy change that kind of clarifies things, and I think that's part of the process, and I'm thankful to law enforcement and the DAs for working with us to make this fit in the Nevada's context. For data from the Innocence Project, we focus first on wrongful convictions, so cases that of people who have been in prison largely for 20, 30 years before it's finally revealed. So just looking at those cases alone, there's been 400 false confessions nationally that have been proven already since 1985. 4 of those have happened in Nevada. None of those have been of children, but they've been of adults, and the developmental challenges of children, I think there's a nexus between those two. That doesn't account for how many cases that don't go to trial in which the child did falsely confess, how many cases are thrown out or don't actually arise to being that were tried correctly, but the person falsely confessed or provided a false statement, but there was other evidence pointing to your guilt that wasn't challenged through a post-conviction context. And then I'll also point to some of my colleagues here this morning who we can follow up with some more data from their research of the IACP basing their recommendations off of the data of brain science and false confessions, interrogators like Wickland and Zalowski basing it off of other data, and then Ms. Cleary, her current research and research she's learned off of around how this all leads into there's a higher probability of this happening, and if there's validity of other tactics, I mean, the UK has been using non-deceptive tactics for over 25 years and have had flying success, then why would we not move to those other areas? I do also want to correct the current constitutional standard for weighing under the totality of circumstances is voluntariness, and the Supreme Court has said voluntariness does not necessitate reliability, and it's up to the states to determine if there's other evidentiary rules that need to go at how do we ensure that confessions are reliable even if they're voluntary.
Thank you for that. At this time, we will open it up for testimony. So anyone that would like to testify in support of Assembly Bill 193, please approach. We will start here in Carson City first. Everyone will have up to 2 minutes to testify. Again, we ask that you state your name and spell it clearly for the record. When you are ready, please proceed.
Thank you, Madam Chair. John Pure from the Clark County Public Defender's Office. False confessions and a conviction of an innocent person are probably my greatest professional fear. This is a bill that would protect against that. This would put safeguards in place for children who, as the speakers before us said, are the most vulnerable. I love my state. I love the people in my state. But we can't act like we look at our state's metrics, we're bad everywhere, so we can't think to ourselves that we're good in this part where nobody else is really good in this part either. So given that this bill is evidence-based, it's science-based, we've looked at juveniles for a long time, this would be a good measure to pass. I will say that the Rocky Mountain Innocence Center is the only regional innocence center. Although a large majority of their cases come from the state of Nevada. So we are woefully behind on investigating cases that we should be investigating. And in fact, only the most serious cases get invested. The problem with juvenile cases is it's a very rehabilitative system where we say, oh, well, we want to get this kid services, we want to do that. And we kind of just brush over if something went wrong or it actually was a wrongful conviction. So these cases would be last to be investigated. They probably would be last for us to even get true data from, I would say. So even with that being said, though, this is a great measure. I urge its passage.
Good morning, Chair, the committee. My name is Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. I'll tell a brief story about when I was in law school. My criminal law procedure professor, who was very adamant about teaching us that we did not have to allow a police officer to enter our home anytime that they came. told us a story about how during the semester, a police officer came to her door, and immediately she let the police officer in, offered him tea, and sat down and began speaking to him. Because in that moment, all of her training had gone out the window, and she saw a police officer standing in front of her, and that's just what she thought she needed to do. And this is a woman who was a law professor. So I want you to think about what happens when a teenager, a child, someone who does not have their parent with them and who is scared to death looking at an authority figure that they may not be familiar with, what they're going to do or say, and we don't know. This bill is an important first step. There are many good police officers out there, but every day we see evidence that they are allowed to, and they do utilize a tactic of giving falsehoods in order to elicit information. When we're talking about adults, that's already a problem. But when we're talking about children, something needs to be done. We support this bill. Thank you very much.
Tanya Brown, spelled TONJABROWN, Advocates for the Inmates and the Innocent. We would like to thank Assemblywoman Gonzalez and the presenters from the Innocence Project and all the experts who have testified before you today. We are in strong support of this bill. We must safeguard the children, the juveniles. And over the years, we have, and you have, the legislative members have heard studies conducted about the brain maturity not developing until the age of 25. And I must say that over the last 2 decades, this has to have been the best presentation I have ever seen. And I hope that you feel the same way. And we strongly support that you pass this bill. Thank you.
Is there anyone else here in Carson City testifying in support? Not seeing anyone, I would like to move to Las Vegas. Is there anyone in Las Vegas that would like to testify in support of 193? Not seeing anyone in Las Vegas. Is there anyone on the phone lines that would like to testify in support of 193? I'll read that number quickly. It's 1-669-900-6833. And the meeting ID is 833-429-0877. Broadcasting, please open the lines for anyone that would like to testify in support of Assembly Bill 193.
Callers, if you would like to testify in support of Assembly Bill 193, please press *9 now to take your place in the queue. If you would like to testify in support of Assembly Bill 193, please press *9 now.
Good morning, Chairwoman Miller, Vice Chairwoman Marzola. My name is Deshaun Jackson. I serve as the Safety and Welfare Policy Director with the Children's Advocacy Alliance. The Children's Advocacy Alliance stands in support of AB 193. We urge the Judiciary Committee to pass AB 193 and put an end to deceptive interrogation practices in Nevada. These practices, as you've heard, have led to false confessions and leading to wrongful convictions of innocent people. As someone that at the age of 14 was falsely accused of abuse allegations and was interrogated and what set off a fight for my freedom, I understand the importance of making sure that interrogations are done correctly and that youth, one, have a voice and that they're well represented. Under AB 193, statements given by juveniles would be inadmissible if law enforcement knowingly lied about evidence and or gave unauthorized promises of leniency in order to elicit statements. The Children's Advocacy Alliance joins countless courts, national law enforcement organizations, interrogation researchers, and high-value detainees in advocating against the use of deceptive tactics. Thank you.
Anne Marie Grant, Advocates for the Inmates and the Innocent, ANNEMARIEGRANT. We are in strong support of AB 193 of the 268 exonerees who were wrongfully convicted as children, 34% falsely confessed. Coercive and deceptive interrogation methods coupled with recognized vulnerabilities of children as a group has led to an unacceptably high rate of false confessions among juvenile suspects. The evidence is clear. The juvenile brain is wired to fall prey to deceptive interrogation tactics. Please support AB 193. Thank you.
Good morning. Jim Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ supports AB 193. To explain why, I want to make an analogy. In Nevada, we have this great law enforcement institution called the Children's Advocacy Center. The people who work at this center interview children who are victims of crimes. The people are specially trained to talk to the kids to get an accurate, true picture of what happened so that the child's statement can be used in a criminal trial. And one of the cardinal rules they have is that they let the kids describe what happened. They don't introduce any factual allegations. They don't make up anything themselves. They certainly don't lie, because that would taint the statement and that would make it harder to hold the perpetrators in those cases accountable. That's all AB 193 is asking for. AB 193 would take this great standard that we already have for the Children's Advocacy Center and help apply it to all children. We believe that all children deserve a fair shake at the truth, and so we support this bill. Thank you.
Hello, everyone. I'm Joseph Camel Jr., and I'm with the Youth Voice Nevada. Assembly Bill 193 is great because it will go against forms of interrogation against a child that can intimidate them in any circumstance, especially with false information. In other words, it goes against lying to a child. As a child is already fragile mentally, and even more so with a peace officer or authority figure during the custodial interrogation. The greatness of this bill will prohibit such measures, stopping the falsehood that will do more damage than good. That's why we at Youth Voice Nevada support this bill. Thank you.
Hello. My name is Ayana, A-Y-A-N-N-A, Oglesby, O-G-L-E-S-B-Y. I am in support of AB 193. I believe this bill is beneficial for the children, especially in the Black and Brown communities who are intimidated and very fearful of law enforcement. I believe AB 193 will add a layer of protection for those children who want to trust the police but aren't able to trust the police. We're Nevada strong, battle born. We have a moral obligation to all Nevadas. And with that, I close. Thank you.
If you would like to testify in support of Assembly Bill 193, please press star 9 now to take your place in the queue. Chair, there are no other callers choosing to testify in support at this time.
Thank you so much. I will open it up then to opposition for Assembly Bill 193. If there's anyone here in Carson City that would like to oppose?
Good morning, Chair Miller and the Assembly Committee on Judiciary. My name is Chris Reese. It's R-I-E-S, and I represent Las Vegas Metropolitan Police Department. As it's written, we are opposed to AB 193. Oftentimes, we use various techniques to assist further investigations that ultimately make our communities safer. It should be noted that these practices also have been used to disprove a person's involvement in a crime. not only to gain confessions. To be clear, any juvenile taken into our custody and prior to custodial interrogation, they all read their Miranda rights. It was AB 132 of last session. We all use that. In fairness, our criminal justice system already has safeguards that ensure that confessions are voluntary and are not coerced. At a basic level, we need to trust our judges and establish case law to determine the admissibility of those confessions. One final point, a confession is not the end of the investigation. There's much more to a case than an admission, and we still need to investigate, making sure that the person confessing to the crime actually committed that crime. We appreciate Assemblywoman Gonzalez and her willingness to work with us, and look forward to continuing to do so. But currently, we oppose AB 193, but are hopeful that we can get to a position of support. Thank you.
Good morning, Chair. Good morning, members of the committee. Jason Walker, Jasonwalker, Washington County Sheriff's Office. We participated in group meetings with the Assemblywoman. Unfortunately, our subject matter expert is unavailable today. I reached out to the Detective Division at the Sheriff's Office. Collectively, they provided me some feedback that I'd like to provide. In summary, and from our collective detective experience with a variety of juvenile subjects related to sexual assault, burglary, murder, and other major crimes, each juvenile subject needs to be evaluated based on the totality of the circumstances, and law enforcement should consider the juvenile's age, education, intellect, and understanding of the situation. The goal of any juvenile interrogation should always be to obtain truthful statements corroborated by evidence and case facts. There may be a scenario where use of false information about evidence could be appropriate for the case facts in a violent gang homicide by a 17-year-old suspect with lengthy juvenile criminal history. In another scenario where a low-intellect 12-year-old sexually assaults a 7-year-old cousin and is more likely to make an incriminating statement when presented with false evidence, but it might be inappropriate based on the totality of the circumstances. Each scenario needs to be evaluated with all the case facts and information about the juvenile suspect. Again, looking through the reasonableness standard, would a reasonable person find the juvenile's statements or admissions voluntary and reasonable based on the entire interrogation and the facts of the case presented? We practice good forensically sound interview techniques that are used in child victim interviews. I am testifying in opposition based on how it's introduced. I am hopeful that communication continues so that we can get to a position of support. And lastly, if I could follow up with Assemblywoman Hardy. In a nutshell, her question was, what is our current interview interrogation method? One child crimes investigator responded back with interview techniques are similar to our victims' forensic interviews, where our goals are person-centered, semi-structured, and forensically sound. Thank you.
Thank you.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in opposition to AB 193. I do want to start off by thanking Assemblywoman Gonzalez and the Innocence Project. We have had several constructive meetings trying to get to a place where we can support this bill. We're not there yet, which is why, pursuant to rules, we're here in opposition. And Chair, with your permission, I do have Bridget Duffy down in Las Vegas. Ms. Duffy is the chief of our juvenile division, and if she may be allowed to continue our opposition.
Are you splitting the 2 minutes, or would she like her own 2 minutes?
Could she have her own 2 minutes, Chair?
Absolutely.
Thank you.
Thank you. Before we go to Las Vegas, is there anyone else here in Carson City that would like to testify in opposition? Okay, then we will proceed with Las Vegas. Ms. Duffy?
Good morning, Chair Miller and members of the Judiciary Committee. I am Bridget Duffy. I'm the Assistant District Attorney of the Juvenile Division in Clark County. Thank you for giving me my own 2 minutes. Hopefully I won't use them all. My opposition here this morning on behalf of the DA Association is not coming from a place that I believe that we should be lying to children in order to obtain confessions. In fact, Nevada case law currently prohibits that. Our case law that's been in effect since 1980 states clearly neither police officers nor juvenile authorities should be allowed to mislead a youth in order to obtain a confession. That case law actually goes on further to talk about how it is my burden as the state to prove the voluntariness of a child's statement. And that could be based on things such as age and maturity of the child and the fact that the child has been read their juvenile Miranda rights. Well, now we have the juvenile Miranda rights. So reading of the Miranda rights. So when presented with this concept by Assemblywoman Gonzalez and the Innocence Project, I was very concerned that under the last 10 years of my tenure over the juvenile division that we were actually not doing a good job in ensuring the voluntariness of statements, and asked that very question that was asked by Assemblyman Yorick is what's my issue here? I take that very personally. And in fact, it made me feel much better to know that we have no examples of juvenile convictions on false confessions here in Nevada at this time. And I would equate that to the fact that we've had case law on the books since 1980 that would have us having to prove the voluntariness of that statement. So I am coming from a practical place in opposition to make sure that when we look at the language of this bill, that it gives some guidance to practitioners in the courtrooms and doesn't forget that we are the ones that will have to determine what we are proving, whether voluntary or involuntary, or where we come from, whether it be the PD's office or their conflict counsel or the state, and how we're doing it and what the court is looking at to determine whether or not that statement is voluntary.
Ms.
So
Duffy?
if this respected, yes.
Those
I was just going to say we look forward to continuing to work with Assemblywoman Gonzalez to ensure clear guidance for attorneys in courts and practice.
Thank you. Is there anyone else in Las Vegas that would like to testify in opposition of Assembly Bill 193? Not seeing anyone. Broadcasting, please open the phone lines.
Callers, if you'd like to testify in opposition to Assembly Bill 193, please press star 9 now to take your place in the queue. If you would like to testify in opposition to Assembly Bill 193, please press star 9 now. Chair, there are no callers choosing to testify in opposition at this time.
Thank you. Then we will open it up for testimony in neutral here in Carson City. Not seeing anyone approach in Carson City for a neutral testimony. Is there anyone in Las Vegas that would like to testify in neutral to Assembly Bill 193? Not seeing anyone in Las Vegas. Broadcasting, is there anyone on the line that would like to testify in neutral?
Callers, if you would like to testify in neutral for Assembly Bill 193, please press star 9 now to take your place in the queue. If you would like to testify in neutral for Assembly Bill 193, please press star 9 now. Chair, there are no callers choosing to testify in neutral at this time.
Okay, thank you. With that, I will welcome Assemblywoman Gonzalez back up to make a few closing remarks.
Thank you so much, Madam Chair and members of the committee. In closing, you've heard from all of our partners on this. We're still working to get to a place of comfortability. I do want to note that on the record, there were conflicting testimonies, right, on we do use this tactic, we don't use this tactic, it's outlawed. And again, the intent of the bill is really to protect our children and false confessions. You've heard from a number of experts in closing. I just hope that we get to a place where we can all agree on language. Thank you.
Thank you for that. And with that, I will go ahead and close the hearing on Assembly Bill 193. I will open the hearing on Assembly Bill 101, which revises provisions relating to informants. And again, this is also sponsored by Assemblywoman Gonzalez. So Assemblywoman, when you are ready, please proceed.
Thank you so much, Madam Chair. Cecilia Gonzalez, Assembly District 16, for the record. I am here today to present to you Assembly Bill 101, which relates to informants in jail or in prison. I just want to make a note of that very important fact that this is regarding informants that are incarcerated. This is not regarding CI informants or any other types of informants that officers may use. Last session, I appeared before this committee and introduced the same bill. And the bill passed in the Assembly and unfortunately died in the Senate, which is why I'm here before you again today. In 2019, the legislature passed Assembly Bill 267, which provided compensation for people who are wrongfully convicted. When Mr. DeMarlo Berry went to prison in 1994 for a murder he did not commit, it was a jailhouse informant who was an incriminating witness. Based on the informant's testimony, Mr. Berry was convicted and sentenced to life in prison. However, in 2014, the informant admitted that he had lied and also received benefits for his false testimony. Testimony from jailhouse informants is one of the leading contributors to wrongful convictions, as you've heard this morning, playing a role in nearly 1 in 5 of the 367 DNA-based exoneree cases nationally. As you've also heard, 4 of those cases were right here in Nevada. So who is an informant? An informant is an individual who provides testimony or information about statements the defendant made while they were incarcerated together. Informants often receive a benefit from prosecutors for such information, usually in the form of a plea bargain or a reduced sentence on their own criminal charge, or a dismissal of their case entirely. Informants can also receive financial incentives or other special benefits while in custody for their testimony. At the very least, the use of jailhouse informant incentives is a distortion to our criminal justice system, and more importantly, the use of unregulated jailhouse informant testimony sends innocent people to prison. I won't go through the sections of the bill. However, Chair, with your permission, I'm going to turn the presentation over to Mr. Nathaniel from the Innocence Project, who does have more details on the 4 cases in Nevada.
Okay, so I would like to ask, we would prefer to hear an explanation of the details of the bill.
Sure.
So if we could cover the policy. Yeah. we appreciate the background and the data, but if we could actually
definitely
go through the policy. Thank you.
Thank you. Cecilia Gonzalez, District 16 for the record. Sections 2 through 5 provide definitions. Section 6 provides that the Office of a prosecuting attorney must maintain complete and systematic records of any cases prosecuted by the office in which the testimony or information was provided by an informant pursuant to a cooperation agreement. Section 7 provides that if a prosecuting attorney intends to use the informant's testimony or information at a hearing or trial, that certain information or materials must be disclosed to the defense as soon as possible, but no later than 30 days before the hearing or trial. In Section 7, subsection 3, the court may order the disclosures to only be made to the attorney for the defendant and not to the defendant or any other party, if, in making the disclosures, that this may result in substantially bodily harm to the informant. And lastly, in Section 7, subsection 4, a court is required to instruct the jury to consider certain information in assessing the credibility of an informant. And that is the bill. Thank you.
Yes, please proceed.
I'm so sorry. I will have Nathaniel go over the amendment. I apologize. There is an amendment from last session, and so I'll have him go through that. Thank you.
Thank you, Madam Chair. For the record, Nathaniel Erb here on behalf of the Innocence Project. I want to thank Assemblywoman Gonzalez and also the District Attorneys Association for working with us closely last year and over the interim on this bill into a place where we're all excited to move it forward. There is a substitute amendment that captures language that I messed up and forgot to add that we had agreed to with the District Attorneys Association. Largely, that adds a lot of clarifying language, but also limits the bill to make sure that we're only talking about situations in which an informant is actually providing testimony in a court case and not just when they're providing information as background. The text of the bill and the purpose of the bill itself comes actually from district attorneys' offices in Texas, similar to AB 193, also coming from district attorneys' offices, which had to do with, in Texas, when they found that there was a prevalent use of jailhouse informants in wrongful conviction cases where they found it was on them that information was not being turned over as was constitutionally required. They found that there was lack of clarity over what the Constitution requires to be turned over as impeaching evidence through Brady, and there weren't complete records. So individual offices themselves themselves, even if one district attorney's office had a lot of good record keeping on where informants are being used, how often they're being used, the deals that are being struck, they couldn't rely on other offices to have that same information, so they could cross-reference to see, is this person testifying across multiple jurisdictions, constantly receiving benefits, constantly asking for things, and they're potentially unreliable. As the Assemblywoman mentioned, there have been a number of cases here in Nevada, as in with other states, that it's found through post-conviction that a lot of information is not provided at the original trial to be able to properly impeach and provide testimony that goes to the credibility of the informant, and that could have helped identify that that person actually was lying at the time of the trial, that they never heard information from the innocent person when they are incarcerated together. I also want to clarify, as the Assemblywoman mentioned, that this only touches on situations where you have someone who's incarcerated in jail with the person who is the defendant, that they have a conversation in that context. That person is then receiving a direct benefit in exchange for providing testimony to the state. It wouldn't touch on other types of information that's gathered. It wouldn't touch on situations where someone's outside of a prison or providing any other type of witness testimony. Largely, the bill already tracks what is current best practice here in Nevada. The first sections of the bill covering disclosure is just tracks and clarifies what should be disclosed under existing constitutional requirements, as other states have established. The other portions of the bill regarding what records attorneys' offices should keep tracks what Nevada District Attorneys Association voted to adopt in 2018, and this just makes sure that practice goes forward. Really the only large piece in the bill that is not existing practice is adding an extra safety valve that requires that if the district attorney feels that some information that they're providing to the defense through discovery potentially could be harmful to the individual, they could then present that to the judge, and there could be a discussion over whether or not the information should be provided or provided in some type of protected context. That existing protection is something that doesn't exist currently under law, but the information covered that's required to be disclosed through the bill is all information that's currently required to be disclosed. So this really just clarifies a lot of what should happen in all these contexts and make sure we avoided these cases in the future. And I think with that, I believe we have a representative from the Rocky Mountain Innocence Center, Ms. Anderson, who can provide testimony on how this has worked locally.
Assemblywoman, is the...
Given time, I think we can just move her section to the testimony. Thank you, Madam Chair.
Okay, thank you, Assemblywoman. With that, then, we will go ahead and open it up for questions. Our first question will be from Assemblywoman Mosca.
Thank you, Chair, and thank you for this presentation. Looking at the amendment under Section 6, so is it records only when the testimony is used? So does that mean if something was promised and it wasn't actually in testimony that it's not recorded somewhere? Or do we have records of that as well?
Nathaniel Erb on behalf of the Innocence Project. Thank you for the question, Assemblywoman. It's likely that the officers are already keeping track of those records. This just requires that if someone actually is provided a benefit in exchange, that we are keeping record of both that benefit that was received and the case in which that was testified, so that when it comes up, if that informant is then later testifying in another case and providing a benefit, that information can then be turned over to the defense to provide, okay, here's this person is providing testimony in exchange for a benefit here. They've also provided in here all these other contexts.
Thank you, Assemblywoman. Our next question is from Assemblyman Urick.
Thank you, Chair, and thank you again for the presentation. I really appreciate the effort in subsection 3 to address the potential safety issue of these informants that come forward. We know that I got cut out. Okay, I'm back. That they provide, a lot of information, intelligence that actually help to keep our prisons and our jails safe. And that always has to be balanced with, there's a big risk, right? We've all heard of the phrase, snitches get stitches. There's a big risk for people to come forward. And so I appreciate the effort to put that in there. I'm having a difficult time understanding as a practical matter. It says that if if a judge finds that the information provided could lead to the possibility of somebody suffering substantial bodily harm, that it would then be viewed by the defense attorney alone. So I appreciate that, but I'm wondering as a practical matter, how does a defense attorney then use this information for the intended purpose without compromising the safety of that informant?
For the record, Nathaniel Erb on behalf of the Innocence Project. First, I just want to set the ground rule that all the information covered by the bill is already currently disclosed, or at least should be, unless the Constitution is being violated, which I don't think it is constantly. The way this is functioned in other states is the attorney could be sanctioned if it's found out that the information provided to the informant. Like, court could say, we're giving you records, this information is for your review to provide background on information. It can't be used in the courtroom, or it could be used in the courtroom in this context. And if you violate that, you'll be sanctioned as a representative of the court. It's largely up to interpretation of rules of how it would function here in Nevada. It hasn't really occurred that much. Largely, this has just been a safety valve. As I mentioned, I'm using that term too much. But it hasn't actually come into play a lot in all the states that have passed this. It's just an extra safe guardrail, because the information covered in the bill is already information that's constitutionally required to be disclosed. And if a defendant was representing themselves pro se, it's information that the Constitution required to hand over to that defendant anyways. But I would imagine that a sanction be put in place if the attorney was violating it and they're not using that information just on background.
Thank you, Assemblyman. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. In Section C, sub 4, is the list that's paragraphs C through F, should that be A through F?
For the record, Nathaniel Erb on behalf of the Innocence Project. Thank you, Assemblywoman, for pointing this out to me yesterday. Yes, it should be.
Okay. Thank you. So can we please do an amendment? Thanks.
Thank you for that technical amendment. With not seeing any additional questions at this time, I will open it up for testimony in support of Assembly Bill 101.
Tanya Brown, spelled TONJABROWN, Advocates for the Inmates and the Innocent. Good morning, members of the Assembly Judiciary. We are submitting our written testimony and exhibits for the public record. On behalf of Advocates for the Inmates and the Innocent, we would like to thank Assemblywoman Gonzalez for bringing this legislation forward. Assembly Bill 101 is a very good bill. It is long overdue. However, we do believe that this bill should be expanded, if not this legislative session, but then in 2025. Section 7, subsection 2, to include a subsection C, that if a prosecuting attorney, as described in subsection 1, withholds evidence that is favorable to the defendant or would call into question the credibility of the witnesses or an informant's testimony, the defendant must receive a new trial. We base this on the following reasons. In 2009, a court order was issued to turn over the district attorney's file in the Nolan Klein case. In the file, the statements were made by one of the state's witnesses. This witness was an informant. She was the leak to the police. She was paid for her testimony through secret witness. We have provided you with those documents to support our testimony, and the courts have continued to this, even to this day, to rely on her truthfulness, her credibility, when she had motive and reasons to lie. We would also ask that you take a look at the exhibits. Some of the exhibits are the investigative notes that were turned over, and that information does support the testimony, and it goes against Brady. Thank you.
Good morning, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office, testifying in support of this bill. You may have noticed over the past few weeks that myself and my colleague, Mr. Pirro, often take a different position and have a different perspective on cases than our colleagues on the other side of the courtroom. I want you to think about that when we're thinking about codifying what is required to already be turned over to us. But when so many people take different positions on cases, what can occur is that certain information is not always turned over to the defense, and sometimes that does include information regarding confidential informants. Confidential informants, there is no evidence that is less reliable than confidential informants, and that is especially true when we are talking about jailhouse informants. Lawyers are often told not to use the word lying when in court, but you guys may have also noticed that I can be quite blunt, and I want to use terminology that is truthful here. Confidential informants can lie. They can give lies to a police officer that will result in false convictions of individuals. And that information needs to be turned over to the defense. This is a tool. This does not change the law. It does not take away any ability of law enforcement to do their job. But this makes very clear what does, in fact, need to be turned over to the defense. And that is why we're supporting this bill. Thank you.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office. I want to thank Assemblywoman Gonzalez and the Innocence Project for coming here and continuing to work on Nevada's issues to make our criminal justice system more fair, more transparent, and better all around. One of the things that happens when I represent clients is that they ask for their discovery in jail. One of my concerns with sending the discovery to the jail is this scenario precisely. Their cellmate reads the discovery and then they're like, oh, he totally told me what happened. He totally confessed to everything. And he basically gives the police and the district attorney a verbatim accounting of what happened from what was written in the police report. So then it sounds very credible, even though it is not credible. So that is one of my concerns. And as Ms. Jancy spoke from the Rocky Mountain Innocence Project, part of that is what happened to Mr. Berry. And that's highly concerning. I think even one person sitting in custody for years of their life for a crime they didn't commit is a problem. And Nevada has been paying millions recently in the last couple of years for those issues. This is something that would stop that. So I highly urge that we pass this measure. Thank you.
Thank you. Is there anyone else here in Carson City that would like to testify in support of AB 101? Not seeing anyone here in Carson City. Is there anyone in Las Vegas? Not seeing anyone approaching Las Vegas. Broadcasting, please open the lines for anyone that would like to testify in support of AB 101.
Callers, if you would like to testify in support of Assembly Bill 101, please press star 9 now to take your place in the queue. Again, if you'd like to testify in support of Assembly Bill 101, please press star 9 now.
Hi, Jim Hoffman representing Nevada Attorneys for Criminal Justice. NACJ supports AB 101. As with AB 193, we believe the core issue here is truth. The point of the justice system is ultimately to find the truth. We can't do that if we don't have all the information. If the defense doesn't know whether someone is a jailhouse informant, they can't put that fact before the judge and the jury. And if the judge or the jury don't know whether someone is a jailhouse informant, they can't fairly judge whether that person is credible, whether they're telling the truth or not. The justice system needs this information to be provided to make sure that our trials are fair and accurate and lead to a true result. AB 101 will help us get there, and we therefore support it. Thank you.
Anne Marie Grant, Advocates for the Inmates and the Innocent, testifying in support of AB 101. I want to point out that in the exhibits that you have been provided in support of our testimony, Exhibit 6 is handwritten notes of a prosecuting attorney on a defendant's motion for discovery, which says, any information reflecting upon the credibility of any prosecution witnesses, including but not limited to criminal records, prior inconsistent or contradictory statements, oral or written, and any consideration of paid, promised, or expected for testimony or information provided or to be provided, in this case, Brady. And what did the DA write next to number 7? He wrote no. As advocates for the inmates and the innocent in our research to help the wrongfully convicted, we have come across exculpatory evidence related to jailhouse informants that would tie an inmate already serving on death row for 2 murders to a 3rd murder that another man was convicted of. This death row inmate was a suspect in this 3rd murder. This jailhouse informant's information implicated the death row inmate in the 3 murders. 2 of the victims could be found in the desert and 1 in Reno. This information is critical to an inmate who has always maintained his innocence, and this info could exonerate him. Please expand the language to allow the wrongfully convicted a chance at a new trial and their freedom either this session or in 2025. We support AB 101, and we encourage you to as well.
Hi, my name is Ayana, Ayanna Oglesby, Oglesby, and I am in support of AB 101. Primarily, I am very familiar with a situation where a jailhouse informant, in writing, the district attorney and judge referred to him as a credible witness. That same credible witness that's a jailhouse informant is also incarcerated in another location outside of Nevada for like charges. Now, I'm familiar with several cases, but I'm almost certain that there's hundreds right here in our state of Nevada. We're not oblivious to people wanting to get lesser time. There was a cliche down in Clark County. The police who use informants would say, "Give us 3 and you'll fly free," which indicates that the person who is the informant had to tell on 3 other people in order to gain their freedom. It is imperative that we initiate this bill and enforce it, because people do want their freedom and they're willing to do anything that it takes. Now, I concur with the advocates for the innocent, Anne Marie, and those in favor of this bill, and I would strongly encourage you to pass this bill. We are Nevada strong and we are battle born, and again, we have a moral obligation to all Nevadans. With that, I close. Thank you.
Callers, if you have recently joined and would like to testify in support of Assembly Bill 101, please press star 9 now. Chair, there are no other callers choosing to participate in support at this time. Oh, 1 second, Chair.
Thank you.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. I have been in the queue. I'm not sure what happened, but my name is Jennifer Noble, Jennifer Noble, and I am testifying on behalf of the Nevada District Attorneys Association. Based on the conceptual amendment posted to Nellis this morning, we do support AB 101. And I want to start by noting that with the incorporation of the conceptual amendment, this bill is not designed to replace or extend the cases of Brady versus Maryland or Giglio versus the United States, or the prosecution's constitutional obligation to disclose exculpatory or impeachment information under current law. Instead, what this is doing is creating a mechanism by which prosecutors' office tracks these incarcerated persons who enter into cooperation agreements from administration to administrations. In other words, they're offering information or testimony in exchange for a plea bargain, reduction of sentence, or immunity. And in the context of a criminal trial, these type of agreements would fall into the category of impeachment information that we are required to give to the defense. The vast majority of DA's offices in Nevada have already adopted policies in place that are consistent with this bill, as it's modified by the conceptual amendment. What we're doing here is making sure that these policies survive from an administration to administration. And we'd also like to thank Assemblywoman Gonzalez and Nathaniel Erb from the Innocence Project for working with us last session and this session. We all approached this issue in good faith and with a willingness to work, and the result is the bill with its conceptual amendment. We are in support.
Chair, there are no other callers at this time.
Okay, thank you for that. In that case, I will go ahead and open up testimony for opposition of AB 101. If there's anyone here in Carson City that would like to testify in opposition, please approach. Not seeing anyone. Is there anyone in Las Vegas who would like to testify in opposition? Also not seeing anyone. Broadcasting, please open the line.
Chair, there are no callers choosing to participate at this time.
Thank you. Then I will open it up for those who would like to testify in neutral of AB 101. If there's anyone here in neutral here in Carson City? Is there anyone in Las Vegas? Also not seeing anyone. Broadcasting, is there anyone on the line that would like to testify in neutral?
Chair, there are no callers to testify in neutral at this time.
All right, thank you. With that, I would like to welcome the bill sponsor back up for final remarks.
Thank you so much, Madam Chair. Thank you so much, members of the committee, for this long morning we've had. I really appreciate it. I did just want to note for those that are new to the committee, if you, have the time to go back and watch AB 267, it's really the genesis of how we got to AB 101. Just some more background information on that and really the cases that came out of Nevada due to this. And I also want to thank all of our law enforcement and district attorney's offices that worked with us to get to a really good place on this bill. Thank you so much.
Thank you, Assemblywoman. And with that, I will go ahead and close the hearing on AB 101. Next on our agenda is public comment. So again, just a reminder to the public, you're able to have up to 2 minutes to make a comment on something that's under the purview of this committee, but not pertaining to the bill hearings that have already been heard and closed. So with that, I would welcome anyone here in Carson City that would like to make public comment.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Some of the things that have been said today, I'm just going to kind of leave it there, but I'm just going to add something that is relevant but not relevant. I will tell you that some time ago, I was contacted by a retired deputy district attorney from the Washoe County District Attorney's Office. He had some information that he gave me, and he strongly suggested and actually made me promise that one day that I would move forward and contact the U.S. Justice Department to look into the Washoe County District Attorney's Office for the way they handle cases and withholding evidence in cases and stuff, and not just including Nolan Klein's case and with the tragic situation that came out of his case, but for others. But I want you to know that. So when you hear things from our district attorney or any district attorney, take it with a grain of salt. Those notes that you have been provided, seldom does anybody ever get to see the handwritten notes or any investigative notes. It's only because of a court order. 99.9% of the people will never get that opportunity, nor their attorneys, to look into that DA's file. And if it hadn't been for the Honorable Judge Brent Adams ordering the Washoe County DA's office, we would have never gotten this information that had been provided to you. So please take that into consideration in anything in the future. And also, we ask that Assembly Bill 49, we put in a proposed amendment for a petition to establish factual innocence posthumously, be brought back before you for a work session. We ask that you pass that. Please allow the families of those loved ones who have passed away the opportunity to exonerate their names. Thank you.
Thank you, Ms. Brown. Is there anyone else here in Carson City that would like to make public comment? Not seeing anyone. Is there anyone in Las Vegas that would like to make public comment? Also not seeing anyone in Las Vegas. Broadcasting, will you please open the line for anyone interested in making public comment?
Callers, if you would like to provide public comment, please press star 9 now to take your place in the queue. Callers, if you would like to provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, private citizen, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office 10/8/2015 during a mental health crisis. When AB 49 is brought back under a work session, I am asking you to consider the Advocates for the Inmates Amendment to AB 49, a petition to establish factual innocence posthumously. And I would just like to remind you all that if law enforcement opposes the bill, it's probably because it levels the playing field for community members, promotes transparency or accountability, and that means that you all should be supporting it. Thank you.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, there are no other callers choosing to provide public comment at this time.
Thank you for that. With that, I will go ahead and close public comment and would just like to thank the members today and everyone that testified. Again, that's the end of today. We will be back here at 8 a.m. tomorrow morning. Thank you. This meeting is adjourned.